Welcome to Channel 17, the Town of Colonie Government Channel.
Hello, I'm Colonie Town Judge Peter Crummey, and welcome to Benchmark. We'll explore a variety of issues involving our legal system, our justice system, and how they intersect with the citizens of the town of Colonie. Today, we are truly fortunate to have Albany County Family Court Support Magistrate Robert Meyer as our guest. Robert Meyer has been serving as support magistrate here in Albany County Family Court since 2004. As we all recognize, the Albany County Family Court in general has an ever-increasing caseload involving a variety of matters, which may have touched a variety of lives here and around the capital region. And I hope you'll join me today in welcoming Robert Meyer. Bob, how are you?
I'm very good. Thank you very much for having me.
Well, thank you for sharing some of your time. Obviously, 1/2 hour would not do justice and cannot do justice to the significant background and experience that you've brought to the citizens of Albany County in your capacity as a support magistrate. You and I have known each other for quite some time, having both attended Albany Law School together. And in that way, and I understand from the law school just last fall that the class of '81 is one of the most distinguished graduating classes, as it turns out. So
I've heard the same thing. Was 81 when we get out, right?
Well, that's what they told me.
Yeah,
yes, that's right. So they're right on that point too. And you were a practicing attorney for quite some time before 2004, when you became full-time as a support magistrate.
That is correct. I practiced in the Albany area from the time I graduated, solo and with firms over that time. I also had the distinct pleasure of clerking on a part-time basis for Anthony Cardona, who just passed. When he was first elected to Albany Family Court, I was his law clerk from his election in 1984 until 1989. Lost a true legal lion last week when Tony passed.
You're not kidding, and in fact, it's funny that it brought his family court position first, because the first case I ever had as an attorney in family court was before him in the building I think now is owned by possibly the Office of Court Administration.
Right.
School.
Correct. Yeah.
And then it moved into temporary quarters way, and now, of course,
we have a gorgeous
Clinton
new
Avenue.
building. Avenue. Yes, they did a beautiful job on our new family court.
Well, I think
facility.
so too. I was there the day it opened. Judge Kay came down from the Court of Appeals to actually preside over the opening day there. And I had a client who had an adoption pending at that particular time, and they asked that we participate in that opening ceremony some years ago. Your caseload is full. In fact, from what I understand, you could actually process over 2,500 cases a year by yourself in connection as a support magistrate.
Right now, there are 3 full-time magistrates in Albany Family Court: myself, Rika Murray, and Rich Rivera. And ideally, and I'm going back to 2004, when my position was created because of the fact that the caseload was becoming a little overwhelming. They actually added a magistrate to the 3rd department, and that comprises 7 counties: Albany, Rensselaer, Columbia, Greene, Schoharie, Ulster, Sullivan. And ideally, back then, what they were trying to do was set it up so that each magistrate would handle about 2,500 cases per year. And that's increasing, because I just had a chance to look at the numbers the other day, and at least those of us in Albany are on pace to be closer to 3,000 cases this year than to 25. I think we're all on pace to do about 2,800 and change.
Well, what you're seeing is the same thing that we're seeing here in the local justice court system as well, that the caseloads increase, and oftentimes the complexity and the style of case is also deeper and more involved than it was previously. Tell me the types of cases that you'll preside over.
Basically, we handle child support, and child support has different areas. Within the framework of child support, there's your basic child support, that dollar amount per week that the non-custodial parent will pay for the support of his or her children. But with that, we are also charged with allocating the cost of daycare if that's being incurred, the cost of any uncovered medical expenses for the children between the parents, and also, and becoming more important each year with the rising cost of health care, the actual cost of the health insurance premium between the parents. In addition to that, if these issues come up, we are also charged with determining each parent's college tuition share. And that can arise in different situations. We can be asked to enforce an existing agreement. When couples become divorced, they have a divorce decree, and sometimes that divorce itself will set forth what their obligations are with respect to college. Sometimes it doesn't, and when it doesn't, we as magistrates have the authority to tell each parent what their respective obligation will be, if any, for their children's college tuition. Can also be tasked to determine if a parent should have an obligation to contribute to private lower school education, be it a private grade school or a private high school, and absent agreement between the parents, we have to look at a myriad of different factors, including the financial resources of the parents, whether there's an acceptable public alternative or what reasons exist for one parent's choice to enroll the children in private school. We are also tasked with determining paternity as well.
Well, the paternity issue is often an interesting issue for a variety of court watchers as well. And what is
Especially Jerry Springer watchers.
Yeah, yeah. Tell us what establishing paternity really means.
In New York State, there are really only 3 ways to determine or to legally determine that someone is the father of a child. If the parties are married at the time the child is born, the law presumes that that child is the child of the respective married couple. Absent a marriage, however, paternity can be established by the parties signing what's called an acknowledgement of paternity. Many times that is signed at the hospital under the auspices of the nurses. They have these forms. That acknowledgement of paternity is signed by both parties, and it does get filed in a statewide repository called the Putative Father Registry, where if you have access to that database, you can determine whether or not that has in fact occurred. The third way is what happens in our court. We have petitions which can be filed by either parent alleging that, on behalf of the father, alleging that he is or that he may be the father, or by the mother of the child alleging that a certain person is the father. They then come into court. They're informed that if they're found to be the father, that they would have the obligation to support the child, but they'd have the right to petition for custody or visitation. Under most circumstances, well, under all circumstances, they have the right to request DNA testing, and we'll get to when that may not happen down the road. And most times that's where we are. People request DNA testing. We have a laboratory that works with Albany Family Court, and we have all of the parties tested. The test is done right at Albany Family Court. Our testing is done on Fridays. It's a very simple procedure. It's a cotton Q-tip, basically, where they take a swab from the inside of mom, dad, and the child, send those out to the lab. They do the genetic analysis to determine whether or not the father's genetic structure, when combined with that of the mother, could have produced the genetic structure of the child. Approximately 4 weeks after the test, we get back a written report setting forth the paternity probability. And the reports come back with, in my experience, the reports either come back and say that there is 0% chance of probability, or that it comes back 99.99% probable that the test subject is in fact the father of the child.
Now, in my own court, in the local criminal court, there are a variety of convictions which require the defendant to provide a DNA sample, most commonly, for instance, a petty larceny conviction. But there's a whole list that continues to grow pursuant to legislative action down at the Capitol each year of convictions which require DNA testing. In your court, can a person be compelled to submit to a DNA test to decide whether they are the parent?
I don't know that it's ever actually been litigated.
Okay.
I take the position that I don't have the authority to compel.
Okay.
So, for instance, if we have a situation where a petition was filed against a gentleman alleging that he's the father of the child, and I go through those rights I just enumerated, and he says, no, I don't want a DNA test. But the mother says, I do. If anyone requests it, or on my own motion if I order it, if there's a failure to comply, I would normally not make any effort to enlist someone else to compel. As an aside, I'm a magistrate, I'm not a judge. And as far as I can tell, the difference between my powers and that of a judge are that I don't have contempt power. So if I wish to punish a failure to comply with a DNA request, I would actually have to refer it to one of the judges. And I do not know of any cases where anyone's been compelled to provide it for a paternity case. So in the alternative, what you do is you would draw an adverse inference from the failure to provide the sample. If you ever got to the case of a trial on the issue, the fact that the putative or alleged father has refused to provide a DNA sample, that fact I would find to be that he didn't provide it because he was cognizant of the fact, he was aware of the fact that his sample would have resulted in a finding that he was the father, and that you draw that adverse inference, and that may in itself be enough, coupled with testimony from the mother, that they did in fact engage in sexual relations at or about the time of conception. That may very well be enough to put the proof over the level of clear and convincing to find that he is in fact the father.
Do you find that there are cases wherein a father brings an action to actually be named by the court as the father of a child?
You do have those situations. I would say that it's probably only about 10% of the paternity cases we get where it's brought by the father, but either parent has the right to seek a determination as to paternity. But it's far more often that they're brought by the woman who had the child.
And do you find that in handling those matters that if there's an allegation or a petition by a mother that a particular party is the father, are there any defenses available to the father other than the DNA? What could that father attempt to establish that that the mother had access to other potential fathers at the time?
And that does happen. And occasionally you even get that situation where the mother does in fact admit that she did in fact have more than one sexual partner at or around the time of conception.
Okay.
And depending upon what the parties want to do, as I indicated, if he's not the father and it was the other partner, the DNA test will show that. But we also have situations where, say you've got a couple who are married, but they've been separated for 5 years. Mom has a child 5 years down the road, and she hasn't even seen Dad in 5 years, but the law says still to me that
right.
The husband is the father of the child. There's that presumption of legitimacy, and you may remember from law school that it was one of the strongest presumptions known to man.
Yeah.
Well, it was a very strong presumption back then because of the lack of scientific evidence available that we do have now. So if you do in fact have that case, you normally would name the husband as a necessary party. He would have to come in. You take sworn testimony from husband and wife as to the non-access. You can then find that the presumption itself has been rebutted and order the DNA testing. And I would normally order it of all 4 people, just so that you would, hopefully get the exclusion on the husband, which would further buttress the fact that the presumption isn't worth anything in this case. And you'd come back, usually in those situations, with a 99.99% probability on the new paramour as opposed to the estranged husband.
Now, I think it's evident today that there are a variety of domestic relationships which don't include marriage. And in a situation where there is a male and a female and a child in one household, and that the male, for instance, was acting as if he was a father in every way, and they were sharing household expenses, and they were doing things as a family unit as defined by state law. And then there comes a time possibly when the dad leaves the residential unit, and then at that point the mother brings an action for support, I would imagine. Even if the man was not found through DNA to be the father of the child, could he still be compelled to be responsible for support?
Yes, and this is one of the more evolving areas of the law, and it's created quite a controversy, quite frankly, because you wind up sometimes with the anomalous situation where, because he's acted as the father of the child, all right, if the case came to court, normally what would happen, if, say you had a 5-year-old where this guy has been involved, acted as the father, child calls him dad. 2 months before the court appearance starts, for some reason dad gets a suspicion. He goes out and has a private DNA test and finds he's not the father. The courts, in certain circumstances, have held that, sorry, you can't deny it anymore. And that ruling is made for the benefit of the child, because between mom, dad, and the child, the court looks at the child as the only truly innocent party. Mom knew, most likely, that if this guy's not the father, there was someone else who could have been. Dad, although he may not have had any knowledge that there was possibly someone else at the time of conception, it can't be denied he had the right to have a DNA test at the time of the child's birth. And thankfully I was going to say these cases are rare, but they're becoming more and more prevalent, unfortunately, with the advent of DNA. You don't have to tell, you take the child on visitation on Saturday, you can go and do a DNA test at a lab, get your test results, and now all of a sudden and then it becomes up to family court or, Supreme Court, and technically I think surrogate's court, but usually it's family court, which has to unravel this family. And our Court of Appeals, the highest court in New York State, has ruled exactly on that, the point you just proffered, that the guy's not the biological father. And unfortunately for him, the courts have said that, you know what, too bad. This is an innocent child, and we're not going to undo the father-child relationship which you've allowed to happen. And of course, sometimes that's incredibly short-sighted, because the very relationship which they're trying to preserve, now that this guy knows he's not the father, who knows whether he's going to continue this and whether it's fostered any real purpose other than the economic. But it's still evolving. And you've got some very strange cases where, with a same-sex couple recently, the Court of Appeals reached the issue where they're making, and this was I believe an artificial insemination with a couple, and the woman who had the baby and her partner eventually split, and you had this estoppel with the 2 female parents, and they made her pay support. But they then said she didn't have the right to visitation because she wasn't the biological parent. And quite frankly, Court of Appeals, if you're listening, it's a result that I just can't get my little brain around, because I always thought that if there was a duty to support, there was a concomitant right to have some benefit of the parental relationship which fostered the right to support. But they don't agree with me. And They're
Yep.
bigger and I'm little.
Well,
So-
and it continues to evolve. And is it the legal term collateral estoppel, which applies
Correct.
to
And
the defense of that's raised by a father, that he's estopped or prevented from raising that defense because at one point it's characterized that he acted as a father.
And that's the exact term that is used. And basically, they're stating that his own actions of fostering and allowing the parental relationship to exist prevents him or stops him from now saying, I want a DNA test, I may not be the father. And the basic rationale is, well, you had that right at the time the child was born. At a certain time, you may lose it. And that makes it difficult because there's no bright line rule or regulation as to when that actually happens.
Right.
There's nothing that says that, okay, you've had a relationship for 18 months, now you've lost it. But obviously, the younger the child, the less of an impact the change would have. So I have an arbitrary rule in my mind. When a paternity case comes in for a child 2 years old or older, I will bring up myself the issue of what contact the putative father has had. And if it sounds like there's been enough contact to at least generate an inquiry, I will appoint an attorney for the child to make further inquiries into the parents and perhaps other relatives and so on, because it gets complicated.
So I suppose it's case by case, and one of the elements to look at is how long the father allegedly participated as a father and what actions he took to demonstrate that he was acting as a father.
It gets, the easier situation is, as you and I spoke of earlier, where the guy lived there for 4 years and the child knew nobody else and then the parents split. But you do get a lot looser type of relationship where, 3-4 times a year, the child's been introduced to this guy as daddy, occasional birthday gift, he does see the guy's mom, his parental grandmother. But the looser the contacts, the more the chance that you might want to do a DNA to find out who the biological father is. And you get into other areas, such as what about the biological father in terms of heredity and diseases, things of that nature, whether there are other siblings involved that are in fact the other biological child of this guy, but he says maybe this kid isn't. Do you tell this kid that his brothers and sisters are now his half brothers and sisters? So there's a lot of context that needs to be seen, and that's why you appoint the attorney to be the eyes and ears of the court and to act in the best interest of the child whose rights are really at stake.
And of course, establishing paternity often flows into support and who's responsible to help raise the child financially.
That's correct.
And support petitions are routine in front of you. Are there particular formulas that apply once you've decided that someone's responsible? And if you make a determination that someone is to make certain payments weekly, biweekly, monthly, what if they don't? So how do you first determine the level of support?
In 1987 or 88, the federal government basically tasked all the states to come up with a uniform system of child support. And ours was enacted, I think it went into effect January of 89. And all the states said, not all of the states are identical, but each state has a firm statutory setup and framework to determine child support. And it's a little more complicated than what I'm about to say, but functionally, the way it works is that as a magistrate, the first thing I need to determine is which parent has primary physical custody of the children. And under New York law, primary physical custody is determined or deemed to be, the primary physical custodian is that parent who has the children more than 50% of the time each week. Once I determine who's the physical custodian, it's the non-physical custodian, the other parent, who has the obligation to pay child support. And child support is really a function of income. And income for child support purposes is all income, no matter where it's derived, and then we deduct only what comes out for Social Security and Medicaid, roughly, historically, 7.65%. Last year it was 5.65 because they dropped Social Security by 2%, and none of us know what it's going to be next year. Once you arrive at that figure, gross minus this FICA, for one child, it's 17% of the remaining amount. 2 children, it goes to 25. 3 children is 29%. 4 children is 31. And then after fight, it's up to a maximum of 35, regardless of how many children that you do have. That is your starting point. That is what the state of New York tells me as the magistrate presiding.
Right.
That is the presumptively correct amount of child support. So in all cases, that's my starting point. We are allowed to deviate or reduce that amount or theoretically increase it, although downward is much more common than upward. And again, this is the base child support component, and we get to that point first. And when we deal with, so that number can be reduced. There are roughly 10 factors specifically set forth which allow me to deviate. And any decision that I do relative to child support, again, after a trial, I have to set forth, and even without a trial, there have to be findings of fact, which basically set forth the income of each parent, what the presumptively correct child support is according to the formula, and then if the parents or if I, after a trial, deviate from that number, I have to specifically set forth the reasons why I've deviated from that number. The other emoluments of support that we have to deal with are setting a percentage for each parent as to, say the child needs braces, and certain with your 4 kids, you've been that route at least once, and it can get expensive. And you have to set forth a percentage of how each parent will be responsible for the uncovered medical costs associated with the child or children. You have to ascertain how much the health insurance is for the kids. Normally what you do is whatever parent's providing the health insurance, they have to get a statement from their employer which says this is how much it would cost for individual coverage, this is what they're paying for the full coverage. The differential between that is the dollar amount which would be split between the parties. The percentage, that too is set by statute. Say mom's the custodian, she makes 40 grand a year, dad makes 60. You look at how their income compares to the whole. Dad makes 60, she makes 40. So dad makes 60% of the entire parental income. He'd be responsible for 60% of the uncovered meds, 60% of the health insurance premium, and mom would be responsible for 40. If dad had the health insurance, what you do is figure out what 40% of that cost is, and whatever mom's 40% is, you deduct it from the child support obligation and just net those out. And that's the basic framework for how the child support establishment process works.
Well, 2 brief issues before we carry on. What if you have a non-custodial parent that won't go to work and says, I don't have any income? What do you do? Well,
thankfully, we have many cases right on point. Believe it or not, there are a lot of people like that out there. And the cases basically say that as the trier of fact, I'm not bound by a party's present financial situation. Obviously, you listen to it, and that's part of the proof. But as the trier of fact, I have the authority, the ability, and quite frankly, the responsibility to set child support based upon a party's income earning potential, their capacity. And you have to set forth where you got it. But one of the, say you were that person. One of the things that I could do is look at historically what you'd made in the past. I can look at your past earnings. Sure. I can look at what your educational background is. I can go to the Bureau of Labor Statistics, which set forth by area what the mean and median wage is for different occupations within the Albany area. So there's a lot of different ways to get there, and for the most part, if I've set forth a sufficient rationale for how I got there, the courts are going to uphold it. I mean, I've had those cases. I've imputed that income, and I haven't had one come back to me on appeal. So.
Bob, tell me this. What if, when you make a support order and someone fails to make those payments, what can be done?
The system works very well with a payor, be it the mother or the father, whoever's ordered to pay the support. If they have a job and they have a paycheck, we won't run into this because the system is set up right now. When I do a support order, right, it has to be payable through the support collection unit unless there's a compelling reason why, and that normally requires the consent of the other party. So if you've got a worker with a paycheck, they send an income execution out, and it usually, you may have some glitches in the very beginning because of the time period to set it up, but once it's online, it works very, very well. The problem you get are those people who either lost their job, never had one, I imputed that income. At that point, the poor custodial parent has to file a violation petition. And what that is just a petition, exactly that. It alleges that he's under an order of child support, that he hasn't paid it. We bring them in, we tell them the rights. If it's an alleged violation, they actually have the right to have me appoint an attorney. The only cases I have the authority to appoint an attorney if they can't afford one are in the paternity cases and in these violation cases. Assume that he hasn't paid, and what happens is that the other determination that has to be made is whether that failure to pay is to be seen as fault-based, a willful violation. If I do determine that there's been a failure to pay, and if I further determine that the failure to pay should be deemed willful, in other words, that it is a fault-based determination, there are various remedies that can be done. The most serious or draconian punishment is actually 180 days in the Albany County Jail. One of the things that we've set up, however, and which has worked fairly well, is what's called the Sheriff's Work Alternative Program. And there are some certain criteria. You can't have a felony conviction to be involved, but they can be ordered to participate in this, which if I say I gave them 90 days in the Sheriff's Work Alternative Program, on 90 separate occasions, usually 5 work days a week, they have to go out to the sheriff's office out at the jail, and they show up for work. And they work 8 hours a day with no compensation. And when I do those orders, we sort of give them a little get out of Sheriff's Work Alternative Program for free card, which says that if you get a job, which comes with a paycheck, which we can garnish, I'll let you off the Sheriff's Work Alternative Program. And this has actually worked fairly well. To me, jail is the last resort. I don't like doing it for a couple reasons. It's certainly not going to generate any support from this person, although occasionally family members will come up with a chunk of change to get their loved one out of the Albany County Jail. But there are certain people who don't have it. There's no way to get it. So really, it's the only purpose of putting them in jail is solely punitive. And sometimes it has to be there. I mean, there has to be some respect for the system, and there has to be the knowledge that if I've exhausted everything I can do, and when people come in on the violations, I'll usually milk those right up until my 6-month period to take care of a case is gone, because my objective is to get them to work. One of the problems we have is we really only have one employment program we can send them to, partially funded by the state. The guy is absolutely buried, and as you well know, the economy stinks. I read something today, for every job opening, there's 4 or 5 applicants. So, and it makes my job harder. When I first started, I used to have this rule of thumb: if you can't get some kind of a job within 3 months, you're not trying. I don't know if I can still continue with that assumption with this economy, because there are people out there who are really legitimately struggling.
Well, I'll tell you, in connection with that probably will continue in that way. You know, I see too that there are other penalties that are imposed in and around the state for failing to pay child support. I see it in my own courtroom through the Department of Motor Vehicles. Oftentimes what they'll do, if they will suspend or revoke a person's privilege to drive for failing to pay child support. So there seems to be a variety of tentacles out there in order to encourage people to do what's been directed by you.
No question. And that actually is done. The support collection unit is set up under the social services law. And they have their separate and totally distinct enforcement mechanisms where they don't need any court orders. They don't have to come to me at all. When the computers are actually triggered to spit these notices out. I think it's that if your support arrears get to the point where they're equivalent to 4 months of missed payments, I think there's automatically a driver's license suspension that goes out. Support collection also has the ability, if they know where your money is, if you're self-employed and you're just not paying because we can't garnish your wages, they find your bank account. They can send out an actual levy which freezes your bank account. And that has been occasionally helpful. And I'm ambivalent about the driver's license suspensions. To me, sometimes it's more of an impediment than it is as any kind of punishment which is going to generate child support. I'm not saying it shouldn't be done, but the problem is sometimes I'm at loggerheads. I have a great relationship with the Albany County Support Collection Unit. I've been in other courts where I technically have no authority to tell the Support Collection Unit to get rid of a suspension. That's their province. There is a procedure where if you don't like it, you internally appeal through social services, and only after that's done do you then have the right to appeal directly, not to me, but to a family court judge, and it's cumbersome, and it's hard. So I can, and did yesterday, as a matter of fact. I had a guy came in to see me, and he complained that, look, I want to go to work, but every place I go tells me I need a driver's license. And I said, if I get your license back before December 31st, when you come back and see me on February 6th, will you have a job? And he guaranteed me he would. So I made the phone call. We gave him his license back, and now the ball's in his court to come back in February and show me that he wasn't lying to me. Because we can always resuspend it. But
well, you continue to lend your background and experience on a variety of matters on behalf of our Albany County Family Court, and I thank you for doing that on behalf of the citizens of the town of Colonie. And we're also very happy that you took time out of your busy day to come share just briefly with us the length and breadth of the cases that are brought before you and how you view them and how you administer justice in the Albany County Family Court on behalf of the support magistrates there. And thank you, Robert Meyer, for joining us today.
Peter,
here.
It was a pleasure. And I can't believe a half hour's over because we didn't cover about 20% of what you've got written on your sheet. It's really been a half hour already?
It only underscores the depth of what you're doing every day here.
Well, you know, I don't realize, I guess, how much is there until you try and put it down and try and encapsulate it in a half-an-hour period. But it was a pleasure.
Well, thank you for the brief primer on behalf of the town of Colonie.
You're most welcome.
And I'm Colonie Town Judge Peter Crummey, and thank you for joining me on Benchmark.